Here's a bombshell that could reshape the debate over presidential power. Trump's own lawyers may have just handed his critics the ammunition they need to prove his tariffs are illegal. But here's where it gets controversial. While 2 federal courts and 10 judges have already ruled against him, the Supreme Court's decision could hinge on a doctrine that's as politically charged as it is legally dubious. Let's break it down. On Wednesday evening, the Trump administration formally petitioned the Supreme Court to review the legality of President Donald Trump's ever-evolving tariff policy. The case, Trump v. V.O.S. selections, is more than just a legal skirmish. It's a test of whether the court will apply the same standards to a Republican president that it used to strike down Democratic policies. And this is the part most people miss. Trump's own petition includes a laundry list of claims about the tariff's economic and political significance that, if taken seriously, would almost require the court to rule against him, if it were consistent. The tariffs, according to Trump's team, are his most significant economic and foreign policy initiative, aimed at closing a $1.2 trillion annual trade deficit and generating $4 trillion in federal savings. Sound familiar? During the Biden administration, the court's Republican majority invoked the so-called major questions doctrine to strike down policies they deemed too significant to be left to executive discretion. In Biden v. Nebraska, 2023, for instance, they torpedoed Biden's student loan forgiveness plan, despite clear statutory authority, because of its staggering $469 to $519 billion price tag. Here's the kicker. If the tariffs are as economically transformative as Trump claims, an independent analyses like Yale's Budget Lab suggest they'll cost the average household $2,400 in 2025 alone, then by the court's own logic, they should be invalid. But will the Republican justices apply the same rules to Trump? Early signs aren't promising. Justice Kavanaugh has already hinted that the major questions doctrine might not apply to foreign policy contexts, a convenient carve-out for Trump's tariffs. Others argue the doctrine doesn't apply when the president acts personally, rather than through an agency. Is this principled legal reasoning, or just partisan rule-bending? The major questions doctrine itself is a legal phantom, invented by the court's Republican majority. It has no basis in the Constitution or federal law. Justice Amy Coney Barrett even tried to justify it using a parable about a babysitter. Hardly a rigorous legal foundation. As Justice Clarence Thomas noted, judge-made doctrines like this are difficult to apply because they lack any real legal grounding. So, is this doctrine a tool for impartial justice or a political weapon? If the court exempts Trump's tariffs, it won't just be a legal decision. It'll be a statement about whose power gets checked and whose gets a free pass. Are we playing by one set of rules for Democrats and another for Republicans? That's the question at the heart of this case, and it's one the court can't dodge forever. What do you think? Is the major questions doctrine a legitimate legal principle or just a partisan invention? Let's hear it in the comments.